Hello, everybody. So welcome back to my English Law channel. And I'm now going to be looking at negligence, which really goes to the heart of tort. The duty of care, which is something that's emerged relatively modern, in relatively modern times. So there are some core principles that we need to examine here. So what are the components of negligence? Well, what's the dictionary definition of negligence? It's saying it's a lack of due care or attention. So it's more or less carelessness. So doing things recklessly, imprudently, with a lack of circumspection, not paying attention to detail, and so forth. And that's where the tort of negligence comes from. So that is a precondition for proving liability in the tort of negligence, but it's not enough on its own. So for an action in negligence to succeed, the claimant must prove a number of components, which I shall adumbrate a little bit later. So the defendant will succeed if any one of them is not proved. So he's going to focus on whichever one of these components is the weakest from the claimant's side. Hill and Chief Constable of West Yorkshire, 1989, is a leading case in this area. So the negligence matrix comprises these four components. First of all, there must be a duty owed to the claimant by the defendant relating to the loss or the injury suffered. Second, the defendant must have done something carelessly or omitted to do something that he was duty bound to do, and that means the breach of duty. Third, there must be a cause and effect relationship between the breach of the said duty and the damage or loss that was flowing from that. And fourthly, the damage or the loss which has been suffered must be of a kind that could be reasonably expected to flow from the breach of the duty. So those four elements. So the claim was brought by the estate of the late Jacqueline Hill. So Jacqueline Hill, deceased, was a victim of Peter Sutcliffe, who was better known as the Yorkshire Ripper, who was a man who was murdering women in Yorkshire in the late 1970s. But I could tell you more about him later, saying, oh, well, I'll just get 10 years in the loony bin. When he went to a psychiatric hospital where he stayed the rest of his life, he was never saved to release. Anyway, so there was a claim for damages on the grounds that the police had been negligent because they had not catched the killer before the victim was slain. So it was arguable that the police hadn't investigated properly, and had they done so diligently, this woman's life would have been saved. So the negligence question was put like this. Did the West Yorkshire Police owe a duty to Miss Hill to protect her, to prevent her murder? And second of all, was the investigation so badly carried out that a reasonable person in a like situation as the defendant would have been careful enough to avoid these mistakes in the investigation? That's the breach of duty question. So you've got is a duty owed? And then the second question is, was there a breach of the said duty? And was the badly executed investigation the proximate cause of the murder of Jacqueline Hill? So that's the causation question, because even if the investigation was badly carried out, that might not have been causative of her murder. Surely what was causative was Peter Sutcliffe killing her. And last of all, was the death a sort of injury or loss which is reasonably foreseeable as arising from a badly carried out investigation? That's a remoteness question. If it's too remote, you can't recover damages. Remember, all four elements must be proven for the claimant to succeed. So despite the harm being reasonably foreseeable, if there's a serial killer on the loose, he's going to kill again. The judges in the House of Lords found that there was not enough proximity between the police and the victim, because in West Yorkshire there are a few million people. So Peter Sutcliffe was randomly murdering women. Some women were prostitutes, some were not. They were young to middle-aged, but apart from that, there was nothing that really united them. So about 500,000 women in West Yorkshire who were in his category, on his hunting ground, as he would see it. So any woman was in jeopardy of being killed by him. But public policy was also a factor in the courts reaching this decision, because their lordships said that this general duty of care to protect the entire public from the consequences of crime is impracticable, because this would wreck police operations. They'd have to say, forget burglary, traffic offences, drug, everything else. We're going to put every single officer into catching the serial killer, which wouldn't guarantee that they managed to do that anyway. And then all the other crimes could shoot up. So the police must be free to conduct their operations as they think. And that's the trouble, is sometimes there's a media circus and people are saying, we've got to catch whoever killer, so let's neglect all the routine police duties because of a hue and cry about one particular very high-profile crime. I remember the abduction of poor Madeleine McCann, that child who was abducted and presumably murdered in 2007 in Portugal, and saying we've got to have tens of thousands of police officers. And I think, well, that doesn't really make it any more likely that the poor child will be found. And she was probably long dead by that time, which is not a reason not to catch a killer. Of course, he should be brought to justice. So there was Robinson, a Chief Constable of West Yorkshire Police in 2018. This case went all the way to the Supreme Court. A woman was injured by a police action. She was a passerby when they effected an arrest, and someone bumped into her, and that caused her to sustain an injury. So the Supreme Court, they threw out the arguments that Hill had established a principle that public policy is a sufficient reason for holding that liability should not be imposed on the police. The absence of the duty of care of the police, based on public policy, was a misunderstanding and misinterpretation of the law. The police, like everybody else, has a duty of care to avoid causing foreseeable injury to another, as was found in Robinson. But the common law doesn't usually impose such a liability for omissions, as in failure to act. The omissions principle, liability is not imposed for omissions to act, more particularly for not preventing harm caused by the behaviour of third parties. So an omission is the not doing something. The argument in that West Yorkshire case was the police had not done something which they're supposed to do, as in investigating properly. Commission is when you actually do something. The police are arresting someone, and as a result of this, they bump into a woman who's passing by in the street and cause her an injury. The police were executing their functions of preventing and investigating crime. They owed a duty of care to avoid occasioning foreseeable harm under the normal principle of negligence. But they did not owe a duty to the public to prevent harm caused by others. So Lord Reed, he gave the leading judgment in the Robinson case, and this is his synopsis on the situation. Public authorities, like private individuals and bodies, are generally under no duty of care to prevent the occurrence of harm. As Lord Toulson said in Michael, the common law does not generally impose liability for pure omissions. This omissions principle has been helpfully summarised by Torfaris and Steele in Negligence Liability for Omissions in the Police, 2016. Here's a quotation from that book. In the tort of negligence, a person A is not under a duty of care to prevent harm occurring to person B through a source of danger not created by A, unless one A has assumed the responsibility to protect B from that danger, and A has done something which prevents another from protecting B from that danger. B has a special level of control over that source of danger, and A state has created an obligation to protect B from that danger. So the Supreme Court judgment in Robinson shows the court moving away from the policy-based justification for not imposing liability on public bodies, and the police is a public body, because the normal principles of negligence to prevent a duty of harm by others will not be imposed unless there's extraordinary circumstances, as adumbrated herein before. The police, they once put a violent white supremacist in a cell with an Asian youth, and then the Asian boy was murdered, something like that, because you had a duty of care to prevent him coming to harm, and you had control over the killer. You could have put him in a separate cell where he wasn't going to kill this Asian youth. All right, that's enough from me at the moment. Toodaloo.